Welcome to another episode of More Bang for Her Buck. This is a show that's about women and money, and I promise you it's jargon-free and fun. Because if we want freedom, then we need to have the money to pay the bills that come with it. Today's episode is particularly exciting for me because over the last couple of weeks, we've been asking you guys on Instagram to send in any questions that you might have about any legal issues. Very often, in the UAE especially, if your money is tied in with companies or with a divorce case or with an issue around the will, then you don't get the financial independence that you thought you would, right? And which is why it's important for us to be able to answer these questions. We found Chandini on Instagram. She runs an Instagram handle called The Bifactology that has 50,000 followers right now and growing rapidly. Probably by the time this episode is out, it'll be at 100K. And she does a day of free legal consultancy with her firm, Malhotra Legal Consultancy. So thanks for being on the show, Chandini.
My pleasure.
At the end of this episode, I can promise you guys, the viewers, that a lot of questions that you have in your minds about the exact rules and laws around employment, around divorce, around wills and death will all be answered. And I've got a big set of questions, so I can't wait to get to it. I want to start by asking you some questions about employment. So this is a story of a dear friend of ours. She was fired by her company when she was 8 months pregnant, right? Okay. And she thinks that it's because the company did not want to pay out those maternity benefits and give her 3 months off or the 45 days off that she would have needed. Her question is, can I sue them? She's also a little bit scared because this company is much, much bigger than she is. So can she sue them, and what's the legal recourse she can take?
First of all, whoever this person is, I feel really sorry for you because this is the time that you should be actually enjoying your pregnancy emotionally as well as at the workplace. Yeah. But if your employer is not that kind enough to consider your case, you do have the legal remedy. If you check the newly introduced federal law, which talks about the relationship between the employer and the employee, you do have a lot of maternity benefits, including the maternity leave. Now, if you read Article 30 provisions of the law, it clearly says that the employer cannot terminate the employee on 3 grounds. One, it's your pregnancy. Second, because you're asking for the maternity leave. Third, because you're absent from the work due to pregnancy-related issues. Now, since the law is very clear on the point, do you think that any employer is stupid enough to tell you that I'm firing you because you're pregnant or because you're asking for the maternity leave? So again, here, I understand that it is a crucial stage in your life, but you have to play a little smarter. When you're pregnant and when you disclose the same fact to the employer, make sure that whatever work you're doing, start documenting it. Because the employer may terminate you in the due course on some other ground. They may say that you're incompetent or you've been coming late to the work. So all the things which you've been doing in routine, just make sure that you're extra particular about it. When you're coming late to the office, just report it to the HR. Whatever work you're doing, make sure that you drop an email timely.
Right.
This is something as a preventive measure that you can take care of.
Right.
But what if you're actually terminated? What do you do? So I told you that Article 30 does give you this protection. But if you're terminated, the first step ideally should be that, again, you approach the employer and explain the situation. Okay? Of course, the employer, in 90% of the cases would not want to consider the case. The second is you can approach the MOHRE. MOHRE is Ministry of Human Resources and Emiratization, which is responsible for all the labor-related matters in the UAE. Now here, again, you have 2 options. If your company has a trade license registered in the free zone, you should ideally be approaching the free zone first. Because free zone also has its own labor authority.
Right.
Usually what happens is the free zone is not a court. So basically, they'll call you as a party and your employer. Understand you're pregnant at this stage. I know it's difficult for you to go, before an authority, but you have to take the first step.
Yeah.
Just go there, approach, they'll try to settle the matter.
Yeah.
Here, you should be very vocal about what you look for. You are entitled to your maternity benefits. You should also get your insurance during when you deliver the child. Also, at the same time, you're also entitled to gratuity and other end of service benefits. If you think that employer is not kind enough to consider your proposal, don't settle. Don't settle for less. Don't settle only because you're pregnant. Okay? In this case, what the free zone authority will do, the labor authority, they'll give you one no objection certificate, which you can take before the MOHRE and file a case before the MOHRE. Now, what's the difference? When you approach the labor court in the free zone, that's a specific authority within that free zone. Okay. Now, when you're approaching MOHRE, it's a federal authority which is applicable throughout the UAE. Now, here again, the first step would be they'll try to settle the matter. if you are apprised of the new development of the law, More is now empowered to settle your matter just like a court would do if your claim is up to 50,000 dirhams.
Right.
So earlier it was just, like a settlement thing. But now if you think overall what you're claiming is 50,000, go and settle the matter, take the money, go back home. If you think that settlement cannot be reached, or again, employer is proposing you something lesser, then the next step is that you approach the court.
Right.
I know, again, it's very difficult for you because you're pregnant, but you've not really done a lot of things. You've just once or twice visited the free zone labor court, and this is the time that you approach the More. First over the phone call, over the hotline number, and this is the first time that you're going, sitting there.
Question, do I need a lawyer to do any of these steps?
Till now, no. Wherever you need a lawyer, I will mention that.
Okay.
No lawyer. You are going and you're sitting opposite to the employer. So till now, it's all settlement that's happening.
Right.
In 90% of the cases, there should be a settlement
at this point. Yeah.
But if not, then you can go to the court. And again, the law also understands that you are pregnant and you should not be spending a lot of time moving to the courts. So again, there's a 14 days time limit prescribed for the courts and More to settle your matter.
Amazing.
Yes. So that's how you can.
Wow.
So the law gives you a remedy. I understand that your position is a little difficult, but you must take all the steps
even
necessary.
If they're big and powerful.
Yes,
companies.
Absolutely. Yeah. That does not... See, every next company is very powerful in the UAE. It's just that you should have the will to take the first step.
Yeah. Great. Thank you so much, Chandini. So the second question is, if someone's behaved inappropriately with me in the office and the company is not taking any action, they don't seem to be doing anything about it, can I sue? And what evidence do I need? And what is not permissible in a court of law? Okay.
First of all, the question does not really say what is inappropriate behavior, right?
Yeah, so that we need to define that first.
Absolutely. Yeah. So it's very, it's very crucial that you first define what is inappropriate. Something could be inappropriate for you, but for me, it could be very cool and casual as well. When I talk about the language of the law, it says that if it's something inappropriate at the workplace, it is usually excessive monitoring by the employer, insult, and they're putting a lot of work pressure, which is beyond required. It could be also in the form of some bullying. It could be by words spoken or something which is written. All these cases are covered under bullying at the workplace. So this is what is the law concerned about when you're talking about inappropriate behavior.
Right.
Not what you consider to be inappropriate.
Right. If someone has groped me at work, or if someone has said something inappropriate to me at work, or has sent me any inappropriate text messages, asking for pictures, things like that. If there's any sort of sexual misconduct in the workplace, how do I go about proving this in a court of law, and should I even bother?
Okay, sexual harassment, it's a very different topic.
Right.
That will, cover later on. Yeah. This is about basic inappropriate behavior, which is usually in the form of bullying.
Okay.
On the part of the employer, it could be from somebody else at the workplace. Right. Now, what you should do, what the law says, let's understand. Again, the new federal law, it's very clear about how should people be behaving at the workplace. That is why the very beginning of the law, under Article 4, it says that there should be no discrimination whatsoever at the workplace on the ground of you being male or a female. And then what is your social origin, what is your nationality, what is your religion, etc. It means law in general prohibits such behavior.
Right.
Now, because the law is prohibiting such behavior, it means there must be some remedy in case something goes wrong. Now, beautifully, for this particular grievance, you have two remedies. You have civil remedy as well as criminal remedy. Now, how do you know what is the difference and which one do you go for? You have to ask yourself the question, what are you looking for in such a case? Do you want the person who troubled you to go to the jail, imprisonment, or you want to settle the matter, you want to take it to the labor authorities, you want to sit and talk it out? Or maybe, you just want to leave the job and take some damages or compensation for mental harassment. So depending upon your remedy, you choose whether you want to go the civil way or the criminal way. If you think that inappropriate behavior should not really come, in the line of your path of success in the same company, just go for the More complaint. Again, the process is same. You call the hotline number, you report the matter, and then they'll call both the parties, settle it. Coming to the documentation, the evidence, you can't, unless you prove something, everything is, just all hearsay. I may claim a lot of things, but I have to have something to prove. Primary evidence should be that, you have some eyewitnesses, you have something which is written, maybe some WhatsApp messages, some official documentation. Then the secondary evidence could be that, some other people testifying on your behalf that this person usually behaves with you like that, etc., etc. I mean, you have to just, law is all logic. You have to just see what all evidence can come together and prove your case.
And WhatsApp is...
of course, now it is. Any form of electronic form of evidence, it's all admissible in the court of law, especially after COVID. Now, this is your civil remedy. Now, here again, federal law gives you another right. It gives you the right that you can quit your job then and there without serving the notice. If you think that you can't take that inappropriate behavior anymore at the workplace. So otherwise, the rule is that you have to serve the notice period. So this is something that you can do away with. And then you go for the settlement, and then, you ask for whatever your end of service benefits are, or you want to settle the matter, that's one. On the other hand, if you think that it's a grave situation and you want to set an example for other male or female colleagues, just file a police complaint. If you're in Dubai or wherever, whichever emirate you're living in, you can do that online, or you can just approach the nearest police station.
And none of these things require a lawyer or
Not at all. Okay,
so you can just go in and...
Yes.
Great. So that's 2 big questions answered. We've got a lot more, but give us a little bit and we'll come back and answer more questions about the workplace and about marriage.
Yeah.
More bang for her buck is a really important conversation around women and money. And if you think that you can contribute, and by this I mean if you've got a case study, a story that you'd like us to discuss with our experts, if you've got a bit of research that you think we should include in the show, or there's an opinion that you think we should feature, we would love to hear from you. Do drop us a DM on Instagram, or you can just email us at info@brownontheoutside.com. There is a feeling around the UAE very often when something happens at the workplace or something happens in a marriage where you feel like, I don't understand the law, I don't know what I'm supposed to do next, and you often settle for less than what you deserve. And that's why we have Chandini on the show, to be able to answer some questions about the law and about how we can move forward. The third is a really important question. It came in to us. This was someone who said that they had been sexually assaulted by a colleague, but she was really afraid to bring it up because she felt that in a UAE court of law, if she is seen as someone who is dating or going out meeting other men on dates, or is seen to be immoral in any way, that this person will get away scot-free and use that as the basis of their case. What are the laws on a matter like this?
Okay. See, the UAE, one of the beauties of the UAE is that they allow you to do everything provided there is consent.
Right.
Whether it's live-in relationships or otherwise, you can do everything but with consent. So you don't have to worry even if you're dating. Your dating is with consent, but the other person sexually harassing you is not with the consent. So don't worry about it. Now, let's talk about what the laws are. First of all, understand what is sexual harassment. Again, it's just like what is appropriate for you may be inappropriate for me. Sexual harassment is basically when first of all, there is consideration on the basis of sex. Somebody is behaving with you differently because of your sex. Second, you find that offensive or unwelcome. So if, for example, your employer or any colleague is just shouting at you because you're not doing your work properly, or is just patting you or touching you, not because of your gender, just because that's how they behave with other employees, this may not necessarily be a case of sexual harassment. First ground that you have to prove before the court of law is that difference in the treatment was meted out to you on the basis of your sex, which you found offensive. Now, in the court of law, there is no general test whether what behavior amounts to sexual harassment or not. As long as you, as the recipient of such behavior, can tell the court that I told this person I don't entertain such behavior, it was unwelcome for me, and you communicated it to the person, this is sexual harassment.
Is that electronically or just verbally?
It could be anyways. As long as you're able to prove it before the court of law, it's done.
So that means if we were at an office party and I said loudly in front of everybody that, hey, this is not cool, don't do this, then it's okay.
Absolutely.
If I've sent him a text message or a WhatsApp or a email, then that's okay. But if it was just said in privacy, then it is not okay.
Absolutely.
Okay. And do we need to have, in order to be able to take this up with the court or with More, should I have communicated that to HR first, or any sort of line manager or anyone else at the workplace?
Absolutely, yeah. So whenever sexual harassment happens against you at the workplace, the first step is ideally that you should approach the HR. In India, luckily, we also have, in every office, we have a sexual harassment redressal committee where the matter goes first. In the UAE, as a general rule, you must approach the HR, and you should document it via official email so that you have the proof. Also, try to attach all the proofs, documents that you have. Even if it's just a statement of a witness or any of the friends in front of whom such behavior was committed, do that. And if you think the HR is not able to do anything or the company is not taking actions, again, you've got two options, civil or criminal.
Right.
Again, you know now where you have to go. If you are looking for something in the form of compensation or damages, approach More. Try to settle the matter, because not everybody wants to leave that job because of one incident or the other.
Correct.
Then More should be the right platform for you.
Right.
Otherwise, if you think that, this person should learn the lesson, then it's better you go to the police.
Right.
Yes. Also, it is very important to understand that how does UAE law define sexual harassment.
Right.
It says that this behavior has to be persistent. Indirectly trying to say that if it's just happening for the first time with you, it's better you stop that person or raise the matter somewhere.
Right.
It's only when the behavior is persistent, that
Right.
is harassing you on the basis of your sex, that is where you have the rightful claim against the accused.
Right.
So in that case, if the company does not have an HR, then who is your go-to person? It could be your manager whom you're reporting to. If there is no manager also, then you can directly write an email to the employer who's
Right.
hired you.
Right. So what if, for example, you had an incident at an office party or an office gathering or just at work one day where there was nobody else there to witness the incident, but this has happened once. It's not enough for that one incident to be taken to court? Do we need to wait for it to happen the second and the third time for it to be treated as a sexual harassment case?
How do you define persistence? It is not necessary that it has to be occasion number 1, 2, and 3.
Right.
It could be just one occasion, but the behavior is repetitive in nature.
Right.
So at the same gathering, at the same party, if you're trying to stop the person is not understanding and he's doing the same thing, this is also a persistent behavior.
Right.
Though there's only one occasion. So that also qualifies for sexual harassment.
I just want to stop and say thank you, Chandini. I don't know how many women watching this right now need to hear this, but thank you. Thank you for knowing, for telling us that the law is on our side and
My
that there
pleasure.
is an option. Now, one of the big reasons that I know women don't report this around the UAE is because you feel that if I report it to HR, or worse, if I take it to More or I take it to a police station, that means I'm going to be fired. And if I get fired, I don't have an alternative job right now and I've got bills to pay. So what's the story what happens when you file a case? If the company then decides to terminate your employment, can you then re-sue them for that? Or how does this work? So if you want to file a complaint, after that, is the employer allowed to fire you or ban you worse still and not allow you to be employed anywhere else?
Okay. See, this question was already thought of before this law was passed. So
Right.
the lawmakers are already very smart. So they could perceive such a situation wherein we're giving employees so many rights, so many grounds on which they can file a case. The employer, of course, in return will probably fire or ban the employees.
Yeah.
So this is already taken care of under the law, under Article 47, which says that if your employment is terminated on the ground of the fact that because you filed a complaint against them, or you filed a complaint against them and it was proven to be true in the court of law, and then you're fired, then you can always contest such a termination or ban before More. So I filed a case or complaint against my employer on any grounds, whether it was sexual harassment, I was not paid salary on time, inappropriate behavior whatsoever. In that case, if I am terminated in the near future, then I, under Article 47, can approach the More 47.
Right.
And I have a rightful claim. 1, to leave the job without notice. 2nd, to ask for the damages and compensation. And 3rd, that the employer should be fined or whatsoever is the penalty under the law.
Right. And when we say near future, what does that mean? Can they wait for 3 months and then fire you? Is it 6 months, 1 year, 3 years? What's the idea of near future?
The law possibly cannot define such a time because the employers also will play smart. A big employer especially, who's always surrounded by a team of highly experienced lawyers, of course he will not do the same thing the same day or in the same month. They will also plan things and execute the things accordingly. So again, you should be able to just connect the dots eventually. Today you did a complaint, after 3-4 months the employer was found to be guilty of doing one thing or the other, and after 3 months you're fired. It looks like as if it was all planned. So it's all about how do you play with the evidence, how are you able to establish a case that everything is connected there too. And the authorities, the people who are sitting at More authorities, who are entertaining your labor claim, they are also smart people, they also have experience, so they can always connect the dots. Yeah.
And one of the big questions that I know people are thinking right now is all this sounds great, but this connecting the dots requires a lawyer. Lawyers require money. Lawyers are expensive. I can't afford it. On this salary, with the threat of my job being lost. Does this still require a lawyer, or is it still something that can be managed just by you in More?
See, if the lawyer was required, the dispute redressal mechanism would have been very different.
Right.
The law would have said that if something happens, go to the court, file a case.
Yeah.
Which means you have an English petition, then you get it translated to Arabic, notary, etc., etc. That is not the case. It just says that you just sit at home, chill, just give us a call on the hotline number 80084. Or you can just download the More app and then do it.
Right.
And then you submit all the documents over the email, attach all the documents. Then they have their own labor claim advisory. They will call you. They will tell you that these are all your rights. What do you want?
And if you want to say, put in a complaint about the company, do you need to inform the company first and then make the complaint, or is it possible to just go ahead and make the complaint?
No,
because
you just make the complaint. The authorities will do the needful. Yeah, absolutely.
Okay, great. One last question with regards to employment in the UAE. A lot of people have freelance work that they do with companies, or maybe they're an intern with a company, which is, there is no legal contract that they have signed. They're not on the company's visa.
Yeah.
If someone does not pay you for freelance work or intern work, what happens then? Can you use an email and say, hey, you promised to pay me, but you never did? So
in that case, I think it is the mistake of the intern or the one who's working as a freelancer, because they have not taken care of the laws at the first place. See, the law does allow students to work part-time, so there are specific regulations for it, and when you adhere to it and you as a student you're working, there's an employment contract. So there has to be some legal proof. You can never claim for any remedy in the court of law unless you have proof.
Right.
So if you are working, you're just working for salary or experience without a proof. So you are at fault. So you can't really claim anything.
So even for freelance work, you would suggest that you draw up a contract and you have that contract submitted to them and you have both parties sign. Otherwise, you can't go to the court and say, hey, you promised you'd pay me 8 grand. Where is it?
See, student intern is different now. Freelancers. Who are freelancers? It's a separate visa category, first of all.
Okay.
And when you apply for the freelance visa, you have to show that you're making good money.
Right.
Not everybody can apply for the freelance visa.
Right.
Now, why does the government give you the freelance visa? So that you can contribute to the tax. Now you're working for somebody, you don't have an employment contract. It means you're taking payments also cash or otherwise. It means you're not even paying the taxes. You may never come in the bracket of corporate tax in future. Then there's no sense. So you are trying to play with the law, then you don't have any remedy. So it's better, even if, this is what I tell even my clients. I've had so many clients, they say, so they give me also some work. They say, just give us the invoice, we'll pay you. We don't need a contract. You don't need it, but I need it. Because it's not about you safeguarding your rights. It's as a company, I also have to safeguard my rights. So it's better, you should always have a contract. Even if it's just for one service, even if it's just for 2,000 dirhams, go for it.
Great.
Yeah.
Thank you. Thank you so much. We're going to do another episode talking about marriage, about wills, because I don't think we could cover everything that we needed out of Chandini. So the next episode is coming right up. This show is produced by Brown on the Outside. A thank you to our production team, The Dark Room, our producer, Sarah Anand, research and intern, Hiral Verma, and on hair and makeup,